Hello. चालेल.
Before we come to this chapter of general exceptions, it is up to the accused to show before the court that his case comes under any of the general exceptions, and that provision is given in section 105 of Indian Evidence Act. So what section 105 of Evidence Act says, I am reading that particular section. Burden of proving that case of accused comes within exceptions. So burden is on the accused to prove that his case comes under any of the general exceptions, and therefore he is entitled to be acquitted. Now, what are those general exceptions? If the case of accused comes within the purview of any of the general exceptions, that accused cannot be convicted. Therefore, the entire act says, if the offence is committed by accused, he is liable for punishment. He is liable for conviction. However, if it is shown by the accused, it is the duty of the accused to show, according to section 105 of Evidence Act. So section 105 of Evidence Act has to be read along with this chapter of general exceptions. So it is the duty of the accused to prove that my case comes under the general exceptions, and therefore I am entitled for acquittal. Now, for that purpose, the first section under the general exceptions is act done by a person bound by mistake or believing himself bound by law. The second section is act of judge when acting judicially. If any government servant is acting by lawful manner, or if any judicial officer is acting or delivering the judgment by judicial manner, relying upon the provisions of law, and if any judge is convicting any accused, for example, accused has committed an offence punishable for death sentence, that is 302, that is the murder. If the accused has committed murder, and if it is the case of arrest of the rare, then accused to be convicted for the death punishment. Death punishment is an exception for the section 302. The first punishment is life imprisonment. So, if accused is to be convicted under section 302, for example, any judge has delivered a judgment and passed order in murder case that this particular accused is found guilty, it has been proved by the prosecution that accused has committed an offence punishable under section 302 of Indian Penal Code, and he is convicted. What conviction has been imposed? The death punishment. This death punishment, after execution of death punishment, there will be a murder of that particular accused. But it is not an offence, because this case comes under section 77, Act of Judge when acting judicially. That judge has delivered the judgment, acting judicially, relying upon the provisions of law, relying upon the procedure given in the Criminal Procedure Code, and he has imposed the punishment which has been provided for section 302 of Indian Penal Code, and he has convicted. premises and the person hanging him is a different person. Even though that person, after hanging that particular accused, he also commits the murder of that person. However, no offense has been committed because that person is acting in pursuant to the judgment and order of the court. So whenever there is an execution of any of the order of the judgment and order of the court, even the judgment and order or any order of the public servant also. So while executing such type of offense has been committed, then section 79 is equivalent to section 78 also, the act uttered by a person justified or by mistake of an act believing himself to be justified by law. So the several ingredients are also required to be taken into consideration for taking the defense. Remember always, all general exceptions are the defenses to be taken by the accused. Now we will see, if the defense is taken by the accused, then it is the task of the defense counsel, advocate appearing for the accused. What is the duty of the prosecution now? What is the duty of the prosecutor? The duty of the prosecutor, if in order to prove the case of the accused within any of the general exceptions, he has to read the defense evidence in order to prove that particular fact. For example, the accused was of unsound mind at the time of commission of the offense. He is not aware or he has no intention, he has no knowledge, and he has committed an offense. Therefore, it is the duty of the accused to prove before the court that he was of unsound mind, he had never intended, he had no knowledge. In order to prove that, there are two modes to prove the case of the accused, that is the defense of the accused. During course of cross-examination of the prosecution witnesses, as well as adducing the defense evidence. In order to prove insanity or unsound mind of the accused, certainly he will examine any medical officer or any doctor to prove that previously he was treated for his unsoundness of mind. And he will produce the certificate. At that time, the prosecutor is required to cross-examine that medical officer, that medical practitioner. Even another type of evidence has been adduced on behalf of prosecution, on behalf of defense. It is necessary to cross-examine the defense witnesses the register from the lodge, or he call the person from that London lodge and examining the in that particular case. And then say that at that 11 time I was at London. So there should be a proximity, time proximity between the offence and the existence of that particular person who can allege that he has committed a particular offence. Now, I am coming another, that is the accident doing lawful act. If you prove that there is a collision of two vehicles on the road, you are saying that it is an accident. Every now and then we are using the word accident. But what happens? Who was either rash or negligent? If anybody found that driving of the vehicle was so rashly, or it was so negligently, and any person died in the said accident, then that person has committed an offence punishable under section 304A of Indian Penal Code. Death due to rash or negligent driving. If that act, you are saying that, or that accused shows before the court, no, it was merely an accident. For accident, it should be without any intention and knowledge. And while doing the lawful act, he was driving lawfully. Both of them were driving lawfully. Inadvertently, this accident occurred and happened. Remember, if it is an accident, no offence. If there is either rashness or negligence has been proved, then it does not come within the purview of the accident, but it is an offence punishable under section 304A of Indian Penal Code. So, in order to prove the offence of accident, what is required? Nothing is an offence which is done by accident or misfortune and without any criminal intention or knowledge. There was no intention or knowledge that I will give cash to the another vehicle. Nobody intended. Nobody had any knowledge. It all of a sudden there was a collision of these two vehicles, and therefore it is merely an accident. So in order to have or prove the accident, what is required to be proved? The ingredients. That the act must have been done accident by or by misfortune. That the act was not an outcome of any criminal intention. The act also was no outcome of any knowledge, and that was done is a lawful. That act was done in a lawful manner, and the act done was in lawful means, and the act was done with proper care and passion. How you will find out is that both of them have taken the care and passion. For that purpose, you will get the evidence of the taking care and passion on the road itself. Whenever there is accident, police person goes there and prepares the spot panchanama. In spot panchanama, there is always road divided white line matka. So to which side of that road divider, that is the white belt, the accident has been occurred, that shows, that decides who was wrong, who has come from the wrong side. Second, if there is a tire mark So what is that speech? What is that evidence? The accident has been committed at the left side of the road, and the opposite side vehicle came to his wrong side. This decides he will give the exactly how that vehicle has come towards this wrong side and collided with that vehicle. Even though that vehicle was going on his own lane, the other vehicle has crossed his lane and came to the wrong side of the road. So these are the circumstances. You will find several differences if you will read the spot Panchanama in accident cases very carefully. Now, sometimes smaller harm is permitted to avoid greater harm. And for that purpose, you have several times you have studied the illustration is given that one boatman was having this boat to a particular direction, and he noticed one boat to his left side and another boat to the right side. Left side boat was having only 3 passengers, and right side boat was having more about 50 passengers. So he has to decide, he has to collide one of that boat. Then he has to decide to collide with the persons having the 3 passengers in order to save the lives of the larger passengers of the 50. And therefore, that particular captain of that ship has not committed an offense, even though those 3 persons, 3 passengers from the smaller boat dies, because there was no opportunity, there was no other alternative available. And in that circumstances, even though he is prosecuted for the commission of that 3 deaths, he is entitled for acquittal because his case comes under the contact purpose. He has to prove all the circumstances available on the record, and then he has to prove that I was having no alternative. In order to save 50 persons, I have done this act, and therefore he is entitled for acquittal. That is section 81. Then section 82 is very simple. Act of a child under 7 years of age. Law says he commits no offense. If the offense is committed by the person, not person but child, less than 7 years, law says he never commits an offense, and therefore, if any child less than 7 years charged with the case of a murder, and if he produces his birth certificate in the court and proves that his age at the time of incident was less than 7 years, he is entitled for acquittal. So what is the task of defense here now? He has to produce the certificate and examine the person who is producing that certificate or who has been immaturity or the understanding of a particular person. So for that purpose, certainly you are required to examine any psychiatrist in order to prove the immaturity or understanding of that particular accused in order to bring his case within the exception, that is the general exceptions, and particular section 83 of Indian Penal Code. Now, the section 84 is also very important, that is the act of person of unsound mind. Law says the person of unsound mind never commits any offense. The unsoundness of mind, there should be a continuity in the unsoundness of mind. Sometimes some persons are of unsound mind periodically. After 3-4 hours, they become regular. After 4-5 hours thereafter, they again become unsound. This unsoundness of mind should be present at the time of actual commission of the offense. So, if any person commits murder, and if it is the case of a particular accused, no, I am insane, I am mentally sick, I am mentally retarded, and therefore I will not commit offense, because person of unsound mind has no intention and knowledge, and therefore for lack of intention and lack of knowledge, he is exempted from such type of particular commission of the offense, and therefore his case comes within the purview of general exceptions. So he has to prove. What he has to prove? Merely unsoundness of mind is not required to be proved. At the particular time of the commission of the offense, he was of unsound mind. It is necessary to prove. And for that purpose, he has to examine any medical practitioner, any medical officer, or if he was already taking any treatment earlier to that certificate it would have been issued, or if the treatment would have been taken, that will be very useful for him. Otherwise, if he fails to prove that he was of unsound mind at the time of commission of the offense, there is no alternative but to convict the accused. Now, the next is the person of intoxication who is incapable of judgment by reason of his intoxication, and if any person consumes liquor and commits offense, in that event his case does not come within the purview of this general exception, because this general exception 85 section says the because we are giving the consent. The patient is giving the consent. If the patient is minor, his guardians are giving the consent to operate the particular person or a particular disease. In that event, if death has been caused, in that event, that medical practitioner is not to be convicted for commission of a murder, because the consent was already given and he acted in good faith in order to save the child, in order to save the patient, and therefore his act comes within the purview of these sections. Then section 89 is act done in good faith for benefit of child or innocent person by consent of the guardian. That is the same, but the consent is of the guardian, as there is no that particular patient is not major. Then we will make the parts of this part of chapter 4 of Indian Penal Code, that is the general exceptions, that is section 76 to 79. 76 and 79. These are dealing with mistake of facts. Section 76 and 79, those are the mistake of acts. Then section 77 and 78, the judicial acts. Then section 80 is accident. Section 81 to 86 and 92 to 94, those are dealing with absence of criminal intention. And section 87 to 91, acts done with the consent. And section 95, that is the trifling act. And section 96 to section 106, that is the right of private defense. You are aware regarding what are the trifling acts? Trifling acts, that is the act is of such a nature that nobody will complain. That is called the trifling acts. And now we will come to the right of private defense, dealing with section 96 to 106, 106. It is said that every human being has a right of private defense. A right of private defense is available for two things: the life of a person and against the property. Now we will think, life of which person? The life of any person. Not only the life who is assaulted of that particular person. He may not be your friend, he may not be your relative, but any person assaults, then right of private defense is available. If during course of exercising right of private defense, a person will commit murder, then he is entitled for acquittal, because he has committed an offense of murder while exercising right of private defense. So, how long and up to what extent the right of private defense is available? For example, the right of private defense is for life or death is available till you are having doubt regarding your life is in danger. The right of private defense against the property is also available till that property is removed from your views, your eyesight. Therefore, the right of private defense is available. Whether the right of private defense is excessive, while exercising right of private defense, you have exceeded your right, then you are punishable for that particular section. If you are not exceeded, that particular accused is entitled for acquittal because he has done that particular offense while exercising his right of private defense. While exercising right of private defense, there should be, there should be a fear in the mind that there is likelihood of commission of my murder. If there is no fear of commission of murder, you have no right to commit the murder of that particular person. I am giving here example. One person came with a knife and in order to attack me, assaulted me. So he was having his knife in hand, endangering my life. There was fear in my mind that certainly he will kill me. Certainly he will commit my murder. So he came and assaulted me. In that event, I can commit his murder because I was having a fear in mind that he will commit my murder because he is having the deadly weapon, knife in his hand. So I am having. But what happened in meantime? As soon as he assaulted, I caught hold his both hands and took out the knife from his hand and assaulted him by knife and committed his murder. Whether I am exempted or not, what offense I have committed? That person came along with a knife in such a fashion that he will assault me and commit my murder. But I caught hold him, took out his knife and stabbed him and committed his murder. Whether I am guilty or not, what offense I have committed? So you are saying I am not guilty. Let me know what is the position. तिकडून मारायला मला माणूस आलाय, त्याच्या हातात असा मोठा जंबे आहे, चाकू आहे. आम्हाला माझ्या मरणाची भीती आहे की तो आता मला मारणार आहे. अशा परिस्थितीत मी त्याला खलास करू शकतो. माझा काही गुन्हा होणार नाही. परंतु तो आला आणि त्याचे मी दोन्ही हात धरले आणि त्याच्या हातातून चाकू काढून माझ्या हातात घेऊन त्याला मी मारला.
खून केला त्याचा. What offense I have committed? Whether I have committed offense or not. Why? Reason is required. The reason is that as soon as you took out the knife from his hand, there is no danger to your life. तुमचा जीव धोका होता का तुमच्या जीवाला? त्याच्या हातातून चाकू घेतल्यानंतर तुमच्या जीवाचा धोका संपला. मग का मारला त्याला? Therefore, in such circumstances, right of private defense is not available. So you have committed murder, and rightly he said that is the culpable homicide not amounting to murder, punishable under section 304 of Indian Penal Code. Because why it is culpable homicide, that will come later on at the time of the distinction of the murder and culpable homicide. Later on we are going to deal with that chapter also. So remember, right of private defense is to be exercised depending upon the force used and depending upon your danger of life. If his act is endangering your life, you can exercise the right of private defense to the extent of his death also. For example, any person is on the road, just going on, and he is committing the offence punishable under section 354. In such capacity, he is outraging the modesty of the woman. You are just passing away. You are noticing this fact. In that event, you cannot say, no, I have to protect only my life, my dignity, or modesty of only my relatives. You are protected to give him fights and rescue that woman. You have committed no offense. So, the right of private defense is to be exercised depending upon the danger to your life and the property. How, whether it was dangerous to your life and property, that depends upon the facts and the circumstances of a particular case. Now, regarding right of private defense, section 100 says, when the right of private defense of the body extends to causing the death. So, the section 97 says, right to private defense of the body and the property. It is available for body. Don't say body of your body only. Whenever there is wrong, you are required to treat as if it is your own body. So there should be apprehension of death in order to exercise the right of private defense. So, if you read section 300, definition of murder, there is one exception. Exceeding the right of private defense, that is not the murder, but it is culpable homicide not amounting to murder. That is the one of the exception of section 300, which is the definition of the murder. Then Section 105 says commencement, when right to private defense commences and up to what time it is to be continued. And then last section, that is section 106, right of private defense against deadly assault when there is a risk of harm to an innocent person. So, if in the exercise of right of private defense against an assault which reasonably causes the apprehension of death, the defense be so situated that he cannot effectually exercise the right without risk of harm to an innocent person, his right of private defense extends to the running of that particular risk. So whenever the risk is continued, the right of private defense is also continued till the running of that risk. Now, regarding the right of private defense, there is always question on this subject, that is the general exceptions. If it is a case examination for the judicial magistrate or even the examination for the assistant public prosecutors. Now, after completion of this chapter, which is a very important chapter, which is giving the benefits to the accused to get the acquittal, and therefore, even though that particular accused has committed an offence, his case comes within the purview of general exceptions. That means accept him, leave him, acquit him, because the conditions given in general exceptions chapter are in existence. They are proved. It is proved that he was of unsound mind. It is proved that he was neither negligent nor rash. It was purely an accident. It is proved that the smaller harm has been committed in order to avoid the greater harm. So, there was in danger to my life, therefore I have committed a murder of that particular person in such a situation. So, this right of private defense, the case has to be proved by the accused. Why? Because section 105 of Evidence Act says, whenever it is the case of the accused that his case comes under within the purview of any of the provisions of the general exceptions, then he has to prove. Remember, there are two types of the proof before the court. For the prosecution, the strict proof is required. But if accused want to prove anything in the same prosecution case, the rule of strict proof is not applicable to the accused. Strict proof is not required to the accused. So, what are the types of the evidence? The first is the possibility. That particular thing is possible. Second is the probability, which is the higher degree of possibility. And then next is the preponderance of probability, which is the higher degree of the probability. And the last stage is the strict proof or proof beyond reasonable doubt. Prosecution has to establish case beyond reasonable doubt. This rule is not applicable to the accused while bringing his case within any of the general exceptions in order to get the acquittal. So what is required to be proved? Strict proof is not required, but for prosecution strict proof is required. And how that mere strict proof is not necessary. That strict proof should be beyond reasonable doubt. But in order to prove the defense of the accused, it is not necessary that he should prove beyond reasonable doubt. By probability, preponderance of probability, the accused can prove that on that day I was at London. That is enough. So this is the mode of proof applicable to the accused and applicable to the prosecution. For prosecution, strict proof is required. For accused, in order to prove his case within the exceptions. Remember, just now I read section 105 of Evidence Act. There is another section in Evidence Act, section 106. Suppose husband and wife are residing in one house. Husband and wife are residing in one house, only one room. In the morning, the wife was found dead in that hut. And her husband was accused in the said case. So it is proved that the accused husband was in custody of her wife. And in such condition, there was no possibility of any other person to enter in and commit the murder of his wife. This is the case of prosecution, that accused husband committed murder of his wife when she was in his custody. In that event, it is also duty of the accused, after the proof of the prosecution, how she died. And this is within the special knowledge of the accused. Read section 106 of Indian Evidence Act, because this is also similar to section 105. That is why I am referring section 106 of Evidence Act. Whenever any case, any fact is within the special knowledge of that particular accused, it is the duty of that accused to prove that particular fact. He has to explain how she died. So, section 105 and 106. Now what happened? It is the case that accused has committed murder of his wife by means of administering her poison. Now, the case is that husband accused administered the poison, and that is why his wife died. The postmortem was done, and during postmortem, medical officer has to opine regarding cause of death. So what was the cause of death? Medical officer opined that she died due to ischemic heart disease. That means she was having heart trouble, and therefore she died. So she died due to ischemic heart disease, and what was the case against him? that husband accused administered a poison, and due to that administration of the poison, husband accused committed murder of his wife. Now the question is here, she never died due to administering of the poison. Medical officer says he has opened the cause of death, that she died due to ischemic heart disease. In that event, what offense has been committed by the accused husband? Now, even though that particular couple was residing together in earlier night in the same hut, and in the next day morning, the wife was found dead, there was no opportunity to others to enter in and commit the murder of that lady. In that event, it is the duty of the accused to explain how she died. Remember, the duty of explanation is entirely different than that of duty of the proof. The burden is not on the accused, it never shifts, but he has to explain how she died. Therefore, he can rely upon the opinion given by the medical officer in the post-mortem report that she died due to ischemic heart disease and not because of the administering of the poison. So, now we are here completing this chapter of general exceptions. Remember, the general exceptions are to be proved by the accused. It is none of the duty of the prosecution to argue a mere single word before the court that this case comes under within the general exceptions. It is to be argued by the defense counsel that this case comes within the purview of general exceptions. And whenever the case comes within the purview of any of the general exceptions, it is the duty of the accused to prove that his case comes within the purview of this particular general exception, that my accused was unsound of mind at the time of the commission of the offense. Then he has to prove that he was of unsound mind at the time of commission of the offense. The accused was intoxicated. He was not aware, he never intended, he had no knowledge to commit such type of the offense. Therefore, in order to bring the case of the accused within the general exceptions, the defense has to lead the evidence. Defense is entitled to lead evidence or prove its case by two ways: by cross-examining the prosecution witnesses or by adducing the defense witnesses. So, we are completing here this chapter, the general exceptions, which are very important, and this is the exemption for the offense, even though committed by a particular accused. Now, I have given the different subjects under this chapter, how it has been to be divided. That is the mistake of fact, that is section 76, 79, judicial acts 77 and 78, accident section 80, absence of criminal intention section 86, 81 to 86, 92 to 94, acts done with the consent section 79, 91, tripling act section 95, and the right of private defense section 96 to 106. Now we will come to the another chapter, that is the criminal conspiracy. So criminal conspiracy has been defined in section 120A, 121A. ज्याला या क्रिमिनल कॉन्स्पिरसीला आपण मराठीमध्ये कट म्हणतो. यांनी असा गुन्हा करण्याचा कट केला. कॉन्स्पिरसी. In order to prove the conspiracy, what is required? 2 or more persons agree together. That means agreement of mind is required. 2 or more persons agree together to do illegal acts. 2 types of acts. One is illegal act and the second is legal act with illegal means. So these are the 4 ingredients. That is the 2 or more persons, agreement of mind of 2 or more persons to do an illegal act or a legal act by illegal means are said to be cause a conspiracy. Remember, it is very difficult to prove the conspiracy in the courts of law. Likewise, it is very difficult to prove the intention of the accused in the courts of law. Because conspiracy never takes place on the open platforms. It is always in the secret. It is agreement of mind is always secret. What both of them or more than 2 decided to do a particular offense. So, it is very difficult to prove the conspiracy in the courts of law because the conspiracy is always in the mind of the accused. It is difficult task of the prosecution to bring that conspiracy from the mind of the accused and bring it on the record of the court. So, whether the accused conspired or not, there is no direct evidence regarding their conspiracy. Whether they conspired a particular act, it will be pointed out by proving the facts and the circumstances. So, there is no direct evidence always in all the cases that there was a conspiracy. So, conspiracy is to be inferred. There is no direct evidence of the conspiracy on record. So, it has to be presumed, it is to be inferred, depending upon the circumstances of a particular case which are brought on the record of the court. Therefore, conspiracy is very difficult to prove in the courts. Likewise, intention is very difficult to prove in the courts. Likewise, the knowledge is very difficult to prove in the courts. We are studying that intention and knowledge when we are dealing with the case of the murder. Criminal conspiracy it has dealt with section 120A, that is the definition of criminal conspiracy. Essential ingredient just now I narrated. and section 120B is the punishing section for the criminal conspiracy, and even though section 120B is a punishing section, no particular punishment is provided for section 120B. It depends upon the offense for which the conspiracy was formed. If the conspiracy is formed for commission of the murder, the punishment is different. That is according to that murder case. If the conspiracy is for commission of the robbery, then punishment is to be as per section 394, that is the robbery. Therefore, conspiracy, section 120B, no specific punishment is provided, but that punishment is depending upon conspiracy for which act two or more persons conspired. Depends upon that. Now, regarding conspiracy, even though it has been defined under section 120A, always remember, when you read section 107 of Indian Penal Code, that is the case of abatement of any offense. There are three modes are given for abatement, and one of the mode is the conspiracy. We are coming later on regarding that chapter of abatement of the particular offense. However, this word conspiracy has been used in section 107 of Indian Penal Code, which defines the abatement. So, section 120B, you have perhaps read, it is always used whenever there is a conspiracy between two or more, amongst two or more accused. If it is case of 302, murder case, 120B. They have committed conspiracy for commission of the murder. Section 394, Indian Penal Code, 120B, Indian Penal Code. That is, they conspired for commission of the robbery. So, conspiracy can be for any particular offense. And just I told, very difficult to prove the conspiracy in the courts of law, very difficult to take out from the mind of the accused and to bring it on the record of the court. Therefore, there is no direct evidence in any case regarding the conspiracy. So, conspiracy is to be inferred. In order to infer the conspiracy, such type of facts and circumstances are required to bring on the record of the court. Now, we will deal with offences against the public tranquility. This is one separate chapter, and you are aware that section 141 is defining the unlawful assembly. Now, we heard in section 120A, two or more persons. Now here, section 141, 5 or more persons. So, what is unlawful assembly? 5 or more persons having a common object. A common object to do a particular offense. So assembly of 5 or more persons. Remember always, there is a much distinction between section 34 of Indian Penal Code and section 149 of Indian Penal Code. We will distinguish later on after studying this unlawful assembly. In unlawful assembly, there is a common object, and under section 34, there is a common intention. This important distinction here, common object, there common intention. So this is a very important distinction between section 34 and section 149 of Indian Penal Code. So the unlawful assembly of 5 or more persons, for example 10 persons gathered for a particular function, it cannot be called as unlawful assembly. Then what is required for naming that particular bunch of persons gathered together as unlawful assembly? And for that purpose, what is that required? The important word is the unlawful purpose. If the gathering of 5 or more persons having a common object and for unlawful purpose, then and then only it can be said it is a unlawful assembly. Mere gathering of 100 or thousands of people together without any unlawful purpose and of common object, it cannot be termed, it cannot be said as unlawful assembly. So what is most important requirement for the unlawful assembly? Gathering of 5 or more persons. Secondly, the common object. And thirdly, the unlawful purpose. So object, unlawful object, it should be illegal object, it should be unlawful object. If the object is lawful, no unlawful assembly. So, if 5 persons gathered together and decided to do a particular unlawful act, to doing that particular unlawful act is the object of that assembly. So, in order to do that object, they gathered together. Then 6th person also came there and joined the gathering of those 5 persons, which we are termed as unlawful assembly. And after gathering, that such 6th person left that place and never participated in the offense. In such circumstances, said person cannot be said as a member of unlawful assembly. If he joined and continued to do a particular illegal act or the offense, even though he joined later on, said person is also called as a member of unlawful assembly. And each of the person of the unlawful assembly is entitled for conviction. The act of any person cannot be separated. For example, out of 5 persons, the 2 persons are having sword in their hands and others were not armed with any deadly weapons. They were not having any weapons in their hands. Only 2 persons were having the swords in the hands, and these 2 persons assaulted. Those 3 persons never assaulted with the sword because they were not having a sword in their hands. In that event, even though they have not assaulted by sword, those 3 persons are also entitled for conviction. Because he was member of unlawful assembly, he was knowing the common object to assault, and the purpose, unlawful purpose. Therefore, even though those 3 persons never committed, they kept mum nearly, mere spectator, still they are to be convicted. The act of any person cannot be separated from one another. So, this unlawful assembly, the punishing section is section 143. Then section 144 is joining unlawful assembly armed with deadly weapons, which is likely to cause death, that is also punishable. Then joining or continuing in unlawful assembly, knowing it has been commanded to disperse, if any public servant or the police commands to disperse the public unlawful assembly, and any of member does not disperse after giving the command, then that person is liable for punishment. Even after giving command to disperse, he has not dispersed. And then the next section is rioting. Riot. What is riot? Riot is using force or violence by unlawful assembly or any member of the unlawful assembly, using the force or violence in order to, for that particular object, common object. So, section 146 is the rioting, which punishes the, which defines the rioting. And section 147 is the punishment for rioting. And larger section is the rioting armed with deadly weapons. So using force with the help of deadly weapons is punishable under section 148. And the last section in this chapter is every member of unlawful assembly is guilty. Every member of unlawful assembly is guilty. And in this section 149, remember, if the 5 or more persons are accused in that event, the investigating officer always applies section 149. For example, 5 or more persons assaulted one person, and one of that person was having axe in his hand and assaulted the victim on his head. So deadly weapon used on the vital part of the body, and there was a grievous hurt. The offence is punishable under section 326 of Indian Penal Code, causing grievous hurt by deadly weapon, only one person was having an axe in his hand, other four are also to be convicted, because the act of individual cannot be separated because there was a common object. So, the important factor is always the common object. Here in section 149, if you read carefully section 149, there is one word used, new, that is K-N-E-W. This word is very important. Whoever joins the unlawful assembly, he must know that this is the unlawful assembly having a common object. And therefore, if he is not aware of common unlawful object, then in that event he cannot be convicted. So what is to be, how a particular person is to be separated from the punishment? That you are required to bring it in on the record of the court that this particular accused was unaware of the object. He was not knowing the object, knew. He doesn't have knowledge. And therefore, he cannot be convicted. It's very difficult to prove the knowledge of the common object. Till today, nobody has applied this word new and got acquitted regarding any of the accused. So this word new is very important, and for example, I will give, you have already come across that example, how a common object is to be identified. Suppose the train is going from Pune to Bombay. I was at Lonavala. I know the object of the train, that it is going to the destination of Bombay. I boarded the train. I have the knowledge of the object of the train, that object of the offence, object of the unlawful assembly, that it goes to Bombay. The object of the assembly is to commit an offence, and in spite of that knowledge, I joined it. Suppose, for example, I joined at Lonavala and got down at Kalyan. Even though for some time I was there, I got down because I came to knew that this is the particular object of this unlawful assembly. I do not want to join, therefore I got down. So in case of unlawful assembly, before doing that particular act, anybody can leave that unlawful assembly. Then he cannot be charged as an offence, he cannot be charged for unlawful assembly, but his leaving, it is his duty to prove that I left before the commission of the act. So, commission of the act by unlawful assembly is also necessary. Mere object or mere unlawful purpose is also not enough. Now, there is always question distinguish between common object and common intention. You study it better and prepare for that. Preparation of these two will help you regarding study of section 34 as well as section 149 also. Now, we will come to the section 153. I think this पावणे 5 झाले ना. Then we will stop it now. Tomorrow we will proceed from section 153A. Thank you. And after this conclusion of lecture, you may have some questions you may ask. From tomorrow you proceed. Okay? उद्या पण हेच माझं कंटिन्युएशन.
सरांनी आपल्या सगळ्यांना IPC वर मार्गदर्शन केलेलं आहे. उद्या 4 वाजता संध्याकाळी सरांचंच लेक्चर